guys, it's Kathy. I hope you're doing well on this Tuesday. So I did do what I said. I did not have an accent all day long, but I had to take my car into the garage and I had to call an Uber to drive me home because, Anthony totaled my other car 2 weeks ago, 1 week ago, I don't even know. So I used I used a southern accent, which I suck at. So it was delicious. It was so much fun. I gave him 5 stars and a tip conducive to having to deal with me in an accent. I don't know if anybody else did. I'm guessing no, because you guys just don't. But you should. When I have a great idea, you guys should just try it. You should just do it, even if it works out badly. I mean, it's not like you're going to jail or anything, right? It was pretty fun. I actually enjoyed myself. Now I want to go out all night, all evening, like to a restaurant or an event or something, a show with a southern accent. And it would be just delicious if someone with a southern accent actually waited on us. I would double down. I'm fixing to get me. They'd probably get really mad at me though, because they probably think I'm making fun of them, but I'm not. I love, 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 love accents, period. So today there is no accent that I know of. I mean, we're going to do Michael Fish. He is so good. He's strict military judge. And, he's very strict, but he does, I cannot do an Australian accent. I know CJ did help. She said don't put an R on the end of the word. It's like ka. But that still doesn't sound right when I say ka. Oh my gosh, there's Beck. Beck, you can help me. You can help me have the bogan has my ka. Doesn't sound like that. Doesn't sound Australian at all. It doesn't sound anything actually. I wonder if it's a skill you can learn to. You're right, you do not have an accent. My daughter is really good at that. She can do accents like nobody's business. And I wonder if it's a skill that you can just teach yourself. Like, I cannot speak French. My mouth cannot pronounce those words, no matter how hard I try. Nar, cow, No, I'm not allowed to put an R on the end of it. There. That sounded pretty Australian to me. Listen, if I start doing an Australian accent, I'm going to have to drink a lot of beer. Because I'm going to have to get into character. And go to a beach. And run from a spider. Which I don't run from because I like spiders. They scare the shit out of me, but I still love them because they get rid of any bugs in your house. Got a spider. You need a spider. Alright guys, we're going to do Michael Fish today. And if you like this, if you enjoyed this as much as I enjoyed it, then I'm thinking on the 27th, he has a packed docket. I know I told you before. I think we're just going to kick back and watch his whole docket on the 27th. If we enjoy this, I got plenty of other stuff. If you guys like, that's going to be too boring. I don't want to do a whole docket. Fine. No problem. We'll do something else. But I really enjoyed this. So here we go. Beck, I love you. I do.
Daniel Nashkoff, state, would you please set a record? What? All right. Now you can see me as well. Yes, sir.
All right. Thank you, Ron. This is State of Indiana versus Daniel Nashkoff. There are 3 cause numbers, 64D01 2407F6 7527, 64D01 2409 CM10033, 64D01 2409F6 10067. The defendant appears in court in person by video conferencing. Is here with counsel, Mr. Steve Pribble. State of Indiana by Gary Gurman.
Morning, Mr. Nashkoff. Can you hear us okay?
Yes, sir.
Mr. Pribble, sir, how can I help?
Your Honor, I need some additional time to see if I can get help Mr. Nashkoff get those funds freed up. I don't believe I'm here next Friday, but I'm here the following.
The 27th, we've already got 22 cases set at not.
Following week?
The 6th, though. Any problem with that, State?
No objection, Your Honor.
All right, Mr. Nashkoff, on defense motion, I'll set your case over until 9 a.m. on March the 6th. Your order to appear back here March the 6th at 9. The delay is charged to the defendant. Do you have any questions, sir?
The delay is charged to the defendant.
The delay is charged to the defendant, sir.
It should be charged to Mr. Pribble for not coming here and getting me my information last month. And that is, this has been going on for over a month. Mr. Pribble and me talked one time. I was ordered by the court ordered to give me more phone time at one point in time, and I only got 2 phone calls in 4 weeks. And then 2 weeks ago, he was going to get me the information off my card, and he still hasn't done it.
Mr. Nashkoff?
Yes, sir.
Mr. Pribble is part of the defense, so it is being charged to Mr. Pribble. But
Okay.
you're the defendant, so it's charged to you.
I would appreciate it if you would get here soon. Thank you.
We'll see you in 3 weeks. Michelle Sacqui, State, would you please set a record?
This is State of Indiana versus Azendis Johnson. Cause number is 64D012601F6921. Defendant appears in court in person by video conferencing without counsel. State of Indiana by Gary Gurman.
Good morning, Mr. Johnson. Good morning, Mr. Johnson. Can you hear me okay?
Yeah. Yeah.
Why are you still in jail?
They didn't release me. I know, they said I got 30 days until, till Wisconsin come get me. I guess, I don't got no charges or nothing like that, but they said, I guess it's up to 30 days until Wisconsin come get me. And then if they don't come, then I guess they're going to release me. And I have to find my way back to Wisconsin. But I guess I got I think probably about like 10 more days or something before Wisconsin got the time to come get me. If not, they said they was gonna have to let me go. But I'm just going off of what the COs was telling me. Logically speaking, I don't even know how it works.
Okay. I mean, I understand the logic of it. State, you want to shed some light on it for me?
Yes, I do, Your Honor. Judge, I believe there's at least a hold on him from Wisconsin. It's an extraditable warrant. But I also believe if there isn't already, there's going to be a federal parole hold as well.
Oh, interesting. Okay. Last time you were here on January 29th, you asked for the public defender service. I tried to qualify you for the public defender and couldn't do so. I don't remember why. Do you still want to try for the public defender service?
Yes.
Okay, please raise your hand to be sworn. Do you swear affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes.
Okay, thanks. What do you do for a living?
Well, I did have a job at the Nature Path, Oregon, but I've been incarcerated for like 3 weeks now, so I know I lost the job.
How much were you earning there?
It was like roughly about $18 an hour, getting paid every week, $20 an hour.
How many hours were you working each week?
There was 12-hour shifts, so you want to get to work like 3 days out of the week, sometimes 4.
Okay. And did you get overtime?
I had to wait until I had to wait until my 90-day probation. After the 90-day probation was up, and then they'll start letting us get overtime.
Did you have any money set aside, or did you have any savings when you were here 2 weeks ago?
No, I had to. I basically was calling around, asking everybody, can they put some money together to bail me out?
Well, it looks like somebody posted your bond for what that's worth, but you're on these other holds. But that's not my question. As far as qualifying you for the public defender service, do you own a car or anything? Do you have any big ticket property items?
Not really. Not nothing that's really worth nothing.
What kind of car do you have?
I don't got a car.
You don't have a car? It must have been the job. I don't recall, like I said. But
No, yeah, because remember when I came to you first time, you had asked me did I have a job, and at that time I did have a job because I was only here for like a week and a half or something, so I know I still had the job.
yeah.
But
Do
so
you have
that's
any kids?
no, I got one on the way.
And are you buying or renting your home?
No, I stay with my mom, but I was
Okay. Are you helping out with rent at your mom's house?
yeah. Once I had a job, I was doing a little, but I ain't even had a job for 90 days yet.
Is the mother of your child living with you?
No,
Were you all on any form of public assistance? You or your mom or your...
Judge, he's in jail. How could she be living with him? Are you asking if she's in jail?
like you mean like food stamps law or something like that, like getting like something like that. That's what you mean?
Okay. Well, I think you're indigent. I'm going to qualify you for the Public Defender Service, appoint the Porter County Public Defender Service to represent you. And we'll see what happens with those holds, especially that federal one. I mean, that'll hem things up here pretty good. But in any event, I already had you set up for a hearing on March the 20th and another one on April the 17th. I'm just going to affirm both of those dates in order to appear back here on those days and times. Do you have any questions about anything?
Not really. I was just trying to see. It's basically it's just a waiting game for me, pretty much, to see if they.
It is, in fact, a waiting game, sir. As far as those holds are concerned, the part in my court, we're not waiting. We're going forward on March 20th, April 17th, and Mr. Pribble is going to be out there to meet with you at a certain point, put a vigorous defense together for you on this charge. Okay?
Yes.
All right. We'll see you back on March the 20th. We're adjourned.
Just a spoiler, that Roger guy that we see walking around and everything, you're not going to see him. It's just a quick set over. So try to ignore him.
Reynold Lindsay, state, would you please set our record?
Yes, Your Honor, thank you. This is State of Indiana versus Reynold Lindsay. Cause number is 64D01-2509F69340. Defendant appears in court in person and with counsel, Mr. Steve Pribble. State of Indiana by Gary Gurman.
Yes, sir.
Your Honor, Mr. Lindsay has informed me that he has already put wheels in motion to hire private counsel on this matter. That's the status.
Okay.
So I don't know if the court wants to,
In that last guy's defense, Bobby, he lives with his mommy. If I lived with my mother, I too would be in jail. Maybe that's why he's in jail. If I had to live with my mother, it would take 2 hours tops before the police carted me away.
relieve the public defender's office at this point or wait, but
Oh, no. We'll see when somebody enters their appearance, how things stand then. Mr. Lindsay,
So,
you hired somebody?
so I was looking around for somebody.
Can you grab the mic and pull it towards your own?
Yes, sir. I was looking around for somebody, so I'm gonna start looking today. My cousin told me about somebody that he had.
Well, so you haven't paid anybody any money yet?
No, I was gonna sign my bond slip over and pay the rest in cash to him.
Okay. Who's your friend tell you to talk to?
I can't think of the name off the top of my neck.
That's fair. That's fair. How much time you think you're going to need to come up with an attorney?
If you can give me like a month.
I can give you 5 weeks.
That's perfect.
Any objection, State?
No objection.
So on defense motion, actually it's Mr. Pribble's motion. I don't want to give the suggestion that we're doing hybrid representation here. March the 20th at 9 a.m. in order to appear back here March the 20th at 9. We'll see what happens in between now and then with regard to a lawyer, okay?
Yes, sir. And I want to apologize for my absence on the last court day. I just came a little late.
I ain't even mad at you. I don't even know what happened. So it's all good.
Okay, that right there got me. And I'm going to tell you what went through my head, and it's not crude, it's just the truth. He had to have sex before he came to work today. There's no other excuse why this judge is acting this way to these people. There's just no other excuse. But that's fine. They should all be happy for that.
All right, thank you.
Okay, thanks. Marnisha Simmons, state, would you please set our record?
Yes, Your Honor, thank you. This is State of Indiana versus Marnisha Simmons. Cause number is 64D01-2412F6-12720. Defendant appears in court in person with counsel, Mr. Steve Pribble, State of Indiana by Gary Gurman.
Looks like I need to do an admit deny on something. Once my screen populates, I'll tell you more about it.
All right, I'm done with my food. Now you guys can chat about food. I'll be fine.
Okay, ma'am, the probation department filed the 5th addendum to the second petition for revocation of probation on February the 11th, 2026. In it, they allege you violated Rule 4 for financial obligations. They say you were behind $310 in your user fees through February of this month. And then they say that you violated Rule 9 for narcotics, and they attach a drug screen from February 4th that is positive for marijuana or THC. Do you understand the allegations in the 5th addendum to the second petition for revocation of your probation?
Yes, sir, but can I?
Whoa. All I need to know is whether you understand, okay?
Yeah.
If it's found that you violated your probation, any part or all of your previously suspended sentence could be imposed as jail time. Additional conditions could be added to your probation, or an additional length of time added to your probation. Any or all of those may occur if it's found that you have violated. Do you understand that?
Yeah.
In a revocation proceeding, you're entitled to a hearing.
You're entitled to a hearing. I'm going to guess before he types. I'm going to guess he had leftovers. He made too much penne the first time, and he finished it today.
At that hearing, the state would have to prove by a preponderance of the evidence that you actually violated your probation. Do you understand that?
Yes.
At that hearing, you'd have the chance to confront and cross-examine witnesses, and if necessary, use the court's subpoena powers to have witnesses brought here to testify on your behalf. Do you understand that?
Yes.
You're also entitled to counsel. Mr. Pribble is involved in your case, and that appointment will stand through this 5th addendum to the second petition as well. Okay?
Or he needed nails, so he got a sausage sandwich.
I'll enter preliminary denial order. Okay, state.
By way of an alternative, Judge, I'm tempted to ask the court to take the defendant into custody this morning. It's the second petition, it's the 5th addendum. In the alternative, I've asked for a very short time and asked that the case be scheduled for a final hearing on these violations.
Okay. You're tempted to ask, but you haven't asked.
May I have 1 second, Your Honor?
You may.
That doesn't say anything. I said two different things. I'm going with he ate leftovers. I would.
Mr. Pribble won't be here next week. The 27th is booked solid, but we have plenty of time on March the 6th.
Actually, Judge, I'm going to ask they should be taken into custody today. This goes way back to September of 2025. That was I just looking at my notes quickly, that was
way back to September of 2025. Shut up.
First addendum to the second petition. So we've been dealing with this since September and actually beyond. So my motion is that she be taken into custody today. Ask for that final hearing to be set on March, did you tell me?
Well, if I take her into custody, I'm going to have to do it in 2 weeks.
All right.
So irrespective of how booked we are that day, that'll be the date of the final hearing. Do you want to respond, sir?
I did, Your Honor.
You want to get the mic?
Your Honor, Ms. Simmons has affirmed to me she has not.
I like hot dogs for dinner.
Last hearing, she unfortunately has surrounded herself with people who have, which may have had some impact on the THC levels which the probation is tested. But I think more importantly, Your Honor, last time we were here, we did indicate to the court that she started the process of obtaining drug treatment, rehabilitation. She has gone through the preliminary stages, the intake process, and she is scheduled to commence her treatment on February 23rd. Our position, Your Honor, is, again, we're not dealing with meth, we're not dealing with heroin, we're not saying marijuana is legal, no one's saying that. But I think the severity of that drug is different from others. And the fact that Ms. Simmons is pursuing some type of treatment, I think it's best if we allow her to pursue that treatment outside of incarceration. And if the court wants to set the final, we can do it.
Okay, so I would flatly reject the notion, and it's ridiculous for you to suggest that you have some sort of a contact high from people around you. Don't shake your head at me.
Or
People around you using marijuana, right? It's not Cheech and Chong in a smoked up van. Like, that's not how this works, and everyone knows it. So that's absurd to the court. All right. When I look at the values on your drug screen, the amount of THC in your system from the last test in January or whenever it was is exactly the same as the amount of THC in your system from this test. A little bit different, but very similar in the amount. Okay. So until you're willing to believe yourself that you've got some sort of a problem that you need to solve with regard to your marijuana use, you're never going to solve it, right? That's how this works. You have to admit that it's a problem for you. And apparently, being on probation for neglect of your dependent child isn't sufficient for you to understand that it would be unwise to carry on using marijuana or THC products, right? And if it wasn't, no, you can't say anything. You can listen. Have you tried to listen before? Maybe, and just take in what somebody's saying? You have. Okay, this is a good time for that. If the amount of THC in your system wasn't so small, I would be taking you into custody on the state's motion right now. Just so you know, I would ask this officer to put handcuffs on you. But because it's such a small amount, even though I think you have an ongoing issue, and your counsel has so eloquently put to me that you now plan to get into treatment, I'm going to allow you to do that. I'm going to have you come back on, I think I said the 6th of March at 9 a.m. Meanwhile, if you get engaged in treatment, get that information to your probation officer, okay? And stop using drugs. And if you're around people who are using drugs, stop being around those people, okay? All right, we'll see you back on March the 6th at 9 a.m. You're ordered to appear, okay?
Everybody in Australia knows what that is. That's a normal, that's like us going to get a Big Mac. It's a sausage sizzle. In Australia, they go to the hardware store and they get a sausage sizzle. And that's what it is. It's a sausage and a piece of bread with ketchup. It's a national pastime to go get a sausage sizzle from Bunnings. And I said it wrong because I don't have an accent.
Thank you. We got a box of Kleenex somewhere.
Thank you, Judge.
Good day, sir. Thank you.
Good day.
Enjoy your President's Day weekend, sir. Thank you. I know you'll be taking some time off on Monday.
Sanger. Never heard it. Snag Sanger. Don't say the R.
Mr. O'Donnell, you have a matter before the court for Everett Green.
Yes, Your Honor.
State, would you please set our record?
Yes, Your Honor. Thank you. This is State of Indiana versus Everett Green. Cause number is 64D012503F63275. Defendant appears in court in person and with counsel, Mr. O'Donnell, State of Indiana by Gary Gurman.
Good morning, sir.
Good morning, Your Honor.
Just so you know, up in the Northeast, the whole Northeast, you don't, only children put ketchup on hot dogs. Like, you don't do that. If you go to New York, they give you mustard because that's what you put on a hot dog, plus all the other toppings if you want. We put a lot of freaking toppings on our hot dogs. It's rare that we just get a hot dog with ketchup and mustard or ketchup. That's what children eat. that's like them giving you a fruit roll up if you're hungry. We put chili and sauerkraut and relish. You can put ketchup on if you put like mustard and relish, but mustard is the #1 condiment to put on a hot dog in the Northeast. Definitely not ketchup. You'll get made fun of by me.
How can I help?
Judge, in this matter, the state has already sent a proposed plea agreement over. I had the chance to review it with my client. I would like to send back a counter proposal. It's somewhat hard for me to get here on Fridays, Judge. If the court, I know, and I've overstayed the using of the Zoom, so I'd like to be here to submit a plea agreement on this case, as well as my other case that I've got set this morning. Is it possible to come in is April 3rd not available because of the holiday you mentioned, or is it?
Bren, next time you go to Bunnings, take a little sauerkraut with you. Just put it in a baggie, take a little sauerkraut with you, and maybe mustard. But you don't have to do that. But, just to skip that. Next time you go, ask for one with none of that on it. And just put sauerkraut on instead. And you'll be like, oh man, this is really good.
Yeah, April 3rd is Good Friday. That's why your court's closed in Lake County too.
So if we could do, if April 10th is available, it will be the final pretrial conference, Judge.
Okay, Terry,
I don't know what you
ketchup
mean by
is
it'll be
fine
the
if it's
final
ketchup
pretrial.
and
I mean,
onions.
it should be
That's
the last
fine.
time we're here.
Okay, so you're going to do a change of plea that day?
Yeah.
Okay, we can set you on April 10th for a change of plea state unless you have an objection.
I do not.
Okay.
Thank you.
You want to do it at 9, 10, or 11?
Can we do it at 10 o'clock? Is that
Yeah.
possible?
You can do it at 11 too if you want.
Thank you, Judge.
So just so you're aware, it wasn't the Zoom that was the problem.
It's
It was
'cause I
the
didn't
fact
file
that
motions,
you couldn't
yeah.
be dedicated to the Zoom because you were too busy working on other things at the same time. So you would come in and out of the hearings, and things would be delayed here, right? And we'd be waiting on you, and then your people would be waiting, and I would be done, but you wouldn't be done. See what I mean?
I
That was the
I
problem.
totally understand, Judge,
Yeah.
and it's hard to do. If it's April, if it's this far out, I can get coverage. I could be here. There could be no hiccups, no issues. So
I'm just saying that if you picked an 11 o'clock hearing time, right, and you were in Lake County and you got done with your call, and at 11 o'clock you stopped doing whatever you're doing in Lake County long enough to do your cases here, like we would work with you on that. See what I mean?
I totally understand what you're saying, Judge.
I just wanna
And
make sure you
I didn't mean
understand.
it as I meant it as a self.
No. I just want to make sure you understand that as long as you're available for the Zoom call at the appointed time, Zoom's no problem. But because you weren't available at those times, it became a problem.
I appreciate it.
So I had a big note next to your name to not allow you to appear by Zoom ever again.
Ever
Just so you're-
again.
But for Mr. Everett Green, I will do as you wish. We will have you come back on April the 10th, sir, at 9 a.m. You're ordered to appear back here at that date and time. Do you have any questions?
No, Your Honor.
Everett Green waited for you one day for hours on end. He can attest, I'm sure. But in any case, we'll see you back on April 10th.
Thank you, Your Honor.
Good day, sir.
Roasted that
And then you have
lawyer.
Aaron Stevens as well, sir?
That's correct, Judge.
All right, let's get the record set
Judge.
for Aaron Stevens.
No, he needs time to cry a little bit. Just give him a second.
State, would you please start a record?
Yes, Your Honor. Thank you. This is State of Indiana versus Aaron Stevens. Cause number 64D012504F64734. Defendant appears in, wait, is she here? Defendant fails to appear. She's here with counsel, Mr. David O'Donnell, State of Indiana by Gary Gurman.
Any word about your client, sir?
Well, Judge, in this matter, Attorney Gurman had tendered a very fair plea that I believe my client will ultimately accept. I heard from her just last night over a Facebook message that, hey, I got a new number. After I had messaged her that, hey, we've got court, we got to make sure you're here. Ever since she's gotten out of treatment, Judge, I haven't had the opportunity to have one-on-one contact with her. So I can't even say where her whereabouts are. Judge.
State.
Your Honor, I know there has been, believe there was a failure to appear before, but we recalled those warrants because she was in an inpatient treatment program in Indianapolis. Just asked that the court take a bench warrant under advisement this morning and order her to appear. I don't know if we can do this next Friday. I know you have a trial, but as soon as possible.
Yeah, the state, as I scroll back through this, back to May of last year, there was a failure to appear, which occurred the week after, 2 weeks after she bonded out of jail. Judge Matsey recalled that. There was a failure to comply on violations of pretrial release, which were failures to appear at that pretrial release. There was a reaffirm the warrant order that was entered back in August. She was picked up on that. There was finally an initial hearing in the case. There was a motion to release her OR for treatment in November. And then there was a pretrial release for her failure to comply, which was not coming to appointments for pretrial release or checking in with pretrial release, which she could have done from her treatment facility. And I recalled a warrant on a failure to comply related to that on January 16th. All issue a bench warrant for her arrest. We'll catch up with her when we have her in custody.
Understood, Judge.
Yeah.
That's all I have this morning.
Ouch.
Thank you, Your Honor.
Thank you, sir. It's a pleasure to see you.
After you roasted him. See, why are men, men are like that? They get into fights and it's like nothing happened. That was a woman. They were two women. 20 years from now, they would still be resenting this day.
Did you get a client there? Is Erin Stevens with us?
Yes, sir, Judge.
Oh, she dodged a bullet this morning, huh?
Possible.
That's the one that he just put a
on
warrant
up.
out. She made it to court, guys.
We're back on the record for Erin Stevens. And Ms. Stevens has joined us. I'll recall the bench warrant I issued about 5 minutes ago.
Thank you.
How can I help?
Judge, as I was saying previously, my client had completed an inpatient program treatments, substance abuse program. Attorney German has sent over to my office a plea agreement that I do believe will be a fair resolution. I would just like to have some time to go over with my client. I was asking for that April 10th date for submission plea hearing, and we'll take any foresee time in between.
Any objection, state?
No objection.
Did I say you at 10 o'clock on your last hearing?
Yes, you did, Judge.
Okay. So April the 10th, ma'am, 10 a.m.
Okay.
Okay. Be on
Thank you.
time.
Thank you, Your Honor.
We won't have any sort of tense moments like we had 5 minutes ago, right? Everything will run smooth.
Oh, thank you. I
right.
appreciate it.
All right.
You have a good day.
Mr. Elwood, you have Lance Washington. Jill, can you hear us okay?
Yes, Your Honor. Thank you.
Okay. Let's go with Lance Washington. State, would you please set a record?
Yes, Your Honor. Thank you. This is State of Indiana versus Lance Washington. There are two cause numbers, 64D012412F6 64D012510CM11448. Defendant appears in court in person by video conferencing. He is here with counsel, Mr. Ken Elwood. State of Indiana by Gary German.
Morning, Mr. Washington. Can you hear us okay?
Yes, sir.
Mr. Elwood?
Judge, I met with the defendant this morning at the jail. We do not have a resolution. I would ask for a trial setting. And I also ask that the court release Mr. Washington, given the amount of time he served versus the amount of time he's exposed to.
When do you want to try it, State?
Judge, I have no real preference. Whatever works for the court schedule.
How many days do you need?
I think there are actually two trials, since there are two separate cases unrelated. I think the F6 case, maybe 2 days, and then the misdemeanor case, probably 1 day.
I agree.
Why are you thanking him? He's trying to put you in pain. Don't thank him. No, Bobby. Do not hurt Monica. I'll cut you.
I mean, my first trial setting is September.
That's fine, Judge.
It's the week of conference. But I'm fine with setting the misdemeanor case on September 1st with the idea you would try that in 1 day. Is that right, State?
I believe so, Your Honor.
I think the F6 is older, Judge.
It is. It's State's choice. Let me back up and see if I can find an earlier date for 2 days.
Back that fang up, Judge. Sorry. Someone's going to time Bobby out, and he's going to deserve it because he's trying to put pain on people.
No, I'm just going to do the September 1st and 2nd. I'm not sure
Don't
what
time
conference
Bobby
is,
out.
but it'll be fine. September 1st and 2nd for the F6.
I think they're supposed to do that. V, I think the judges are supposed to think out loud. They all do it. Sandra, why would you want peppers?
That one, if I back up from there to August the 7th, and trial that day, August the 30, or July the 31st, rather, for a pretrial conference. And then touching base for trial readiness.
I'm sorry, Judge. What was the date of the pretrial?
July 31st.
Thank you.
June's kind of tough. We've got trials and then Juneteenth holidays on 19th. Be out that first Friday, but let me do a trial readiness on May the 15th at 9 a.m. 10 o'clock rather. You want to do it at 10?
That's fine, Judge.
You want to do the pretrial at 10 as well?
Yes, please.
Okay.
Same, Brad.
So let me see if I can find a date then for the misdemeanor.
Don't worry, Mr. Washington has things to say, guys.
I can work it in on
Getting there.
September 24th.
That's fine, Judge.
And because it's so close, I'm just going to do the other dates same time. We need real court time for any motions on either trial. We'll set real court time. Does that sound good?
Yes.
Is that okay with you, State?
It is, Your Honor.
All right. So, Mr. Washington, I Set a trial by jury in F6-12572 for September 1st and 2nd at 9 a.m. You're ordered to appear for that. And I set another jury trial on September 24th at 9 a.m. That's on CM 11448. You're ordered to appear for that. There's a pretrial conference on both cases on July 31st at 10 and a trial readiness on May the 15th at 10. That's with the understanding that if anybody needs court time for any motions prior to the trial, that we'll set that court time as the need presents. So you're ordered to appear on all those days. If you fail to appear for either one of your jury trials, we'll hold those trials in your absence and you can still be convicted even if you're not present. You understand that, sir?
Yes, sir.
Okay. And then I had a motion regarding his release, state.
I'm absolutely 100% opposed to the defendant's release on his own recognizance. He's been nothing but belligerent during his court proceedings. Not only the facts of the case, but his disdain for the court's authority indicates to me there's a high likelihood that he is not going to appear and follow the court's orders. In addition, I consider him a danger to the community.
I got him mixed up with someone else. He does not melt down. I saved him because of that.
So I'm asking that the bond remain the same.
Okay, thank you. My records show that there are 450 days of exposure roundabout. And we're at 422 or so right now. But I'm willing to grant the motion. Lance Washington, I'll release you on your own recognizance from jail. I'm going to put you on pretrial release. You need to report to our pretrial services office at 157 Franklin Street and get started on the pretrial release program. What I don't know is anything about your criminal history. Let me just look up something real quick because I have to make a determination about the fees for pretrial services and such like that. You are indigent. If you get out of jail, you're going to be able to go back to work?
I don't know, man. Never been out of jail before.
Okay. Well, I will. You say you've never been out of jail before?
No. I've never been to jail before.
Well, you've never been in jail before? You don't have any prior arrests for anything? Do you have no prior arrests?
No history, criminal history at all.
Convictions? Okay. I'll show you.
Not at all.
I'll show he has no prior convictions and will not be assessed any pretrial services fees. So I'll see you back here then first time on May the 15th at 10 a.m. They'll give you your dates in the jail. And then July the 31st at 10, okay? 157 Franklin Street's about half a block from the courthouse. You need to come down here today and get signed up on pretrial services, okay?
Yes, yes, sir. Is that any time of the day?
Level 1 supervision. Say again, sir?
Is there any time of the day to come there on Franklin Street?
They won't be here much past 4 o'clock today. You should try to get in by at least 3. I think they'll be able to book you out of the jail in a reasonable enough time for you to make it without issue. But if you don't get there today, for whatever reason, hems you up at the jail, do you have a ride?
No, I shouldn't have right now, shouldn't I? Everybody should be working. Everybody should be working. So, what's today, Friday? No, I shouldn't right now.
Lucky for you, it's going to be 60 degrees, man. So if you're out there on the Rolls Royce, it won't be that cold.
Yeah. Yes, sir. I'll scroll straight over. I'll scroll straight over if I can. I don't know what that.
The other option is 8:30 in the morning on Tuesday, because Monday's President's Day. Nobody's going to be in that office. So at the latest, you need to be there before noon on Tuesday at 157 Franklin Street. Okay.
Yeah, that'll work. That'll work.
Okay.
Mr. Washington, this is Ken Elwood, your public defender. Please get a hold of me when you get out.
Yes, sir. Yes, sir.
Okay. We're adjourned. Brian McGee, stay, would you please set a record?
Yes, Your Honor. Thank you. This is State of Indiana versus Arthur Taylor. The cause number is 64D01-2501F6958. Defendant appears in court in person and with counsel, Mr. Justin Camper, State of Indiana by Gary Gurman. This is a sentencing hearing, Your Honor. I've reviewed the pre-sentence report. I offer no additions or corrections to that report. I have no evidence or argument.
Thank you, sir. Mr. Camper, anything on the pre-sentence report?
No, Judge, no correction.
Any evidence or argument for sentencing, sir?
No, Judge.
Okay.
Okay, it's not as good as Dodge Patas, but it's still really good. The Rolls Royce.
Mr. Taylor, this is your chance to say whatever you might like to say before I rule on the case. Okay. Yeah. Mr. Taylor, this is your chance to say whatever you might like to say before I rule on the case. Would you like to exercise that right, sir?
Let's see if you want. Judge, he doesn't want to say anything at this time.
Okay. Mr. Camper, what is your intention related to the non-suspended portion? Normally, after I do this sentence, I say the words, please take Mr. Taylor into custody.
Yeah, I understand, Judge. So Mr. Taylor is a full-time student and also working. I did talk with the state about this prior to. He's agreeable to just doing weekends. He's going to lose his job if he has to do 2 weeks out of jail. So he just, I mean, he has no. It's not a violent crime. He's been cooperating with court. I do believe he'll be successful. He just asked to do it on weekends. I believe it's just got how many days that is total, but I believe he can.
It's all 30 total.
Yeah, all 30. So
15 weekends.
yeah, I know. And my client explained to my client for several weeks about this. We talked about the different options and things of that nature. And he told me that to be able to provide for his family, he believes that the best route.
State, do you have any position?
I do not, Your Honor.
Yeah.
Either option is acceptable to me.
Okay.
So I guess I do have a position.
All right. If you choose not to decide, you still made a choice, right?
Yes.
Yeah. Well, okay. I'm willing to accept the recommendation of plea negotiation. Pursuant to that, enter judgment of conviction on count 1 theft, a level 6 felony. We'll find the aggravators, the history of criminal or delinquent behavior, and recent violations of the conditions of probation or pretrial release. Sentence you to 545 days in the Indiana Department of Correction, suspending all but 30 days. You'll do 30 days as weekends out at the Porter County Jail. Do 515 days on formal probation. There's one actual day of time served.
I dearly, dearly, dearly wish, Sandra, instead of me showing defendants that, oh God, I lost the word. I hate getting older. Disrespect the court. I wish I could show patients that disrespects nurses on here instead, so that they can feel a little shame for the way they treat nurses. Oh, I wish I could do that every day. Instead of courts, patients. But you're not allowed to do that because of HIPAA. Okay. And a whole bunch of other things. But I'm just going to blame HIPAA because everybody blames HIPAA.
Guess that would cut you down to 14 weekends at the Porter County Jail, which ain't so bad.
Oh, but it would be nice.
State won't object to misdemeanor treatment after successful completion of formal probation. There's an amount of restitution of $1,175.93. That will be paid from the bond. Is there sufficient bond to cover that?
I believe so, Judge.
There is. State, you want to approach with that?
Yes, Your Honor. Thank you.
Thank you, sir.
I've already told her boss. I called her boss and said she ain't sick. She's a nurse. Yeah, but I say that every day I leave work. Every single day. I'm never coming back here. I am never coming back here again. They don't pay me enough for this.
The credit day is January 29th, 2025. What was a cash bond posted from the cash bond? The court will retain court cost, probation, initial administration fee, jail booking, sheriff's death benefit fee. We'll hang on to this $1,175.93 for the restitution amount. There'll be a remainder. Where will that go, Mr. Camper?
It'll go to my office, Judge.
I have a bond assignment from Justin Camper. It was signed by Arthur Leon Taylor. Did you post your own bond, Mr. Taylor?
Yes.
Okay. So let me check something here. Yep. So the remainder will be paid over to Mr. Camper on the assignment. And so I need you to go from here to the probation department and get started on the probation requirement. And then they will help you contact the jail. What's your schedule look like on a Friday?
Okay, so I currently do I do 3 p.m. to 1 a.m. However, I can talk with my supervisor actually, as soon as I leave here, I can call my supervisor and see if, until I'm done serving the weekends, if I can get off earlier on Friday, so I can just turn myself in on Friday.
That's usually a 6 p.m. report time for weekend.
Yeah, so I can probably go in at 6 a.m. maybe, get off at 6, maybe like 4, because I do 10 hours right now. So I can maybe go in at 6 to 4 and go turn myself in by 6.
Okay. Yeah, if you don't surrender yourself out at the jail and make arrangements with the jail that work for your work schedule, you're going to be charged most likely with escape or something of that nature.
Yeah.
So be wary of that.
Okay.
And work with your attorney, work with the probation department, work with the Porter County Jail to make sure that you get your time going.
Do I talk to the jail or the probation office?
Go to probation, get signed up for probation, and then they can work with you as well to make contact with the jail. I would go out to the jail as well.
Okay.
And talk to them about getting yourself booked in.
Okay.
Yeah, and your work schedule.
All right.
But I'm going to put in my order that you have to report at 6 p.m. on Fridays.
Thank you.
Okay. All right. Anything else?
He nailed it. Like I couldn't place this judge who he reminded me of for a while, because we've been watching this judge for a bit now, for months. So Tina says the judge's voice sounds like, is it Imar, the tilted lawyer? I don't know. Omar, the tilted lawyer. I don't know who that is, but it's Bull from Night Court. T told us that a couple weeks ago. She's like, he looks like Bull from Night Court. He does. Get rid of those glasses. You look like Bull from Night Court.
On that, Mr. Camper?
No, Judge, that's correct.
Are there any further questions, sir?
He was asking when his release day, if he turns himself in at 6 p.m. on Fridays.
6 p.m. on Sunday.
6 p.m. on Sunday.
Yeah. All right.
Starting his weekends next weekend, Your Honor?
I would start him today, but did you work today?
Yeah, I do.
I'll start him next Friday. Yeah, that's fine. Starting on February 20th, 2026.
Thank you so much. Thank you so much, Your Honor.
All right. Thank you. We're adjourned. Good luck.
Thank you, Judge.
Please do cheat on me. Please do enjoy the other channels. The better that all the other channels do, the better we all do. Seriously. And if you want company, while you guys are watching court somewhere, put it in Discord. Hey guys, I'm watching this blah 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 here. And we can all join you. And we can all have fun all day. Every day. Nothing but court.
Mr. Camper, you
Hour
have
after
Jacqueline
hour.
Britton as well.
Yeah.
Would you please set a record?
Yes, Your Honor, thank you. This is State of Indiana versus Jacqueline Britton. Cause number is 64D01-2502F61146. Defendant appears in court in person and with counsel, Mr. Justin Camper. State of Indiana by Gary Germer.
It's also sentencing, I believe, Mr. Prosecutor. Are we ready to proceed today?
Yes, Judge. I think there was kind of an issue with the factual basis the last time we were here. I have prepared and sent to Mr. Camper a new plea agreement. And so I think we're going to proceed with that new plea agreement and then conclude the case today with sentencing. This is my understanding.
CJ didn't see
I
the
see a new
sausage
plea agreement
sizzle,
in the file.
So I'm showing CJ what we were looking at earlier.
Is that your intention, Mr. Camper?
Yes, sir.
Ms. Britton, please raise your hand to be sworn. You swear affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, sir.
Thank you. Can you grab the mic and pull it towards you?
Thank you.
Please state your full name for the record.
Jacqueline Domingo Britton II.
What's your middle name?
Domingo.
Okay. Have you ever used any other name?
No.
How old are you?
39.
Court has been informed that you wish to change your plea to guilty.
Yes, sir.
Once I pull it up here. On count 1, possession of cocaine or a narcotic drug, a level 6 felony. Is that correct?
Yes, sir.
Before I can accept any guilty plea, I need to ask you some questions.
Okay.
Anytime you don't understand a question, let me know and I'll explain. Anytime you'd like to speak with your attorney before answering, let me know and you'll be allowed to do that.
Okay.
Have you ever been treated for any mental illness or do you now suffer from any mental or emotional disability?
No, sir.
Are you currently under the influence of any alcohol or drugs?
No, sir.
To count 1, possession of cocaine or a narcotic drug, a level 6 felony, how do you now plead?
Guilty.
Ms. Britton, you have the right to a public and speedy trial by jury. Do you understand that?
Yes.
You have the right to face all witnesses against you, to see, hear, question, and cross-examine those witnesses. Do you understand that?
Yes, sir.
You have the right to require witnesses to be present at any hearing or trial to testify on your behalf, and the court will assist you in exercising that right by issuing subpoenas. Do you understand that?
Yes, sir.
The state of Indiana must prove beyond a reasonable doubt that you committed the offense charged before you could be found guilty of that offense. Do you understand that?
Yes, sir.
You cannot be forced to make any statement or to testify against yourself at any hearing or trial, but have the right to remain silent. Did you understand that?
Yes, sir.
If you were to have a trial and were found guilty, you would have the right to appeal your conviction to the Indiana Court of Appeals. Do you understand that?
Yes, sir.
By pleading guilty, you're giving up all of the rights that I've just gone through. You understand that?
Yes, sir.
You have the, by your pleading guilty, the court will proceed with judgment of conviction and sentencing without a trial being held. Do you understand that?
Yes, sir.
Possible penalty for a level 6 felony is from between 6 months to 2.5 years in prison and up to a $10,000 fine. Do you understand that possible penalty?
Yes, sir.
If you have any previous criminal convictions or previous juvenile delinquent adjudications, those may cause an increase in your sentence, or they may prevent the court from suspending part of your sentence. Do you understand that?
Yes, sir.
Are you currently on parole or probation anywhere?
No, sir.
Other than this case, are you out on bond on any charges anywhere?
No, sir.
This plea of guilty may cause harsher sentences for any future crimes. You understand that?
Yes, sir.
The court received a 4-page document entitled Recommendation of Plea Negotiation. The document appears to bear your signature about a third of the way down on the 4th page. Did you sign this agreement?
Yes, sir.
Did you read it before you signed it?
Yes, I did.
Looks like an electronic signature. Did you sign it by email?
Yes.
Did you have a chance to speak with Mr. Camper before you signed it?
Yes, I did.
And before you signed it, did you understand all of its terms completely?
Yes, I did.
Okay. As I understand the sentencing portion of the agreement, you'll be sentenced to 360 days in the Porter County Jail with all but time served suspended. You'll spend the balance on formal probation and pay the related fees. Upon successful completion of probation, you may request judgment of conviction be modified to a Class A misdemeanor, and you can transfer the probation to Missouri upon payment of the transfer fee. You'll also pay the criminal offense mandatory fee, which is a $200 drug abuse prosecution, interdiction, and correction fee. Is that the entirety of the sentence as you understand it to be?
Yes, sir.
Have you or anyone else received any promises or been given anything of value to cause you to enter this plea of guilty?
No, sir.
Has anyone forced or threatened or placed you or anyone else in fear to cause you to enter this plea of guilty?
No, sir.
I told you that you would receive credit for your time served awaiting disposition. You understand that?
Yes, sir.
You realize I'm not a party to this agreement, but I'll be bound by its terms at your sentencing. If I choose to accept it, I'll be bound by your terms at your sentencing and with regard to any future sentence modification.
Yes, sir.
Okay. Your attorney is going to ask you some questions to establish what we call the factual basis for your plea. Please give him your attention. Mr. Camper.
Yes, sir.
About 9 p.m., is that correct?
Yes, sir.
And you were driving a vehicle, is that correct?
Yes.
And eventually you had got pulled across the street, is that correct?
Yes.
And during their investigation, they proceeded to search the vehicle, is that correct?
Yes.
And in that vehicle, there was a blue drawstring bag, is that correct?
Yes.
And that blue drawstring bag, your bag, is that correct?
Yes.
And inside of that blue drawstring bag was it was cocaine, correct?
Yes. The little baggies.
It was in a little bag,
Yeah.
correct?
Yep.
And you knew it was cocaine, is that
Yes,
correct?
sir.
And all this occurred in Porter County, Indiana?
Yes, sir.
You didn't have a valid prescription for that, correct?
No, sir.
Thank you, State.
No questions, Your Honor. Would offer the affidavit of probable cause as further support of the factual basis insofar it relates to count 1.
We'll show that admitted insofar as it applies to count 1. I don't have any additional questions. Court finds the defendant understands the nature of the charge against her to which she has pled guilty, that she understands the possible sentence for that charge, that her plea has been made freely and voluntarily, and there's a basis in fact for the plea of guilty. Moving into sentencing then, State?
Yes, Judge, if we may, there was a pre-sentence report prepared. I have no additions or corrections to that report, and I have no evidence or argument.
Thank you. Anything on the pre-sentence report?
No, Judge.
Any evidence or argument for sentencing, sir?
That's exactly.
Ms. Britton, this is your chance to say whatever you might like to say before I rule on the case. Would you like to exercise that right?
I have nothing to say.
Okay, thank you.
Mhm.
Do you know the transfer fee to Missouri?
No.
Do you plan to go back to Missouri today?
Yeah. I just came back. I just got off the highway.
Okay, you understand that you're not allowed to leave the state of Indiana until you pay the transfer fee, which
Yes,
is
sir.
$355.
Yes, sir.
You have that cash available today?
Yes, sir.
Okay, that's big. I just want to make sure
Yes.
before we do this that you're prepared for that.
Yes, sir.
Otherwise, you're going to have to figure out what to do with the Super 8 or whatever. But in any case, because you have that money available, I will accept the recommendation of plea negotiation. Pursuant to that, enter judgment of conviction on count 1, possession of cocaine, a level 6 felony, dismissing counts 2 and 3. I'll sentence you to 360 days in the Porter County Jail with all but time served suspended. You'll spend the balance on formal probation and pay the related fees. On successful completion of probation, you can request judgment of conviction be modified to a Class A misdemeanor, and you may transfer your probation to state of Missouri upon payment of the transfer fee in cash. You also pay a criminal offense mandatory fee, which is a $200 drug abuse prosecution, interdiction, and correction fee. There was a cash bond posted in the matter. From the cash bond, the court will retain court cost, probation initial and administrative fee, jail booking, and sheriff's benefit fee. I'll also pick up that mandatory fee from that bond money. The remainder goes where, Counselor?
We'll go back.
Okay. Are you still at 1771 East 8th,
Yes, sir.
number 210,
That's my current address. Yes, sir.
Kansas City,
Yes, sir.
Missouri, 64106?
Yes, sir.
So the balance of the bond will be refunded to you at that address.
Okay.
It'll take them about 60 days probably.
Okay. Thank you.
And then I need you to go from here to the probation department and get started with the probation requirement.
Okay.
They'll also work with you to pay the required funds to transfer the probation to Missouri.
Okay.
And they'll work on that transfer. That office is at 157 Franklin Street, which is just out, you know where it is?
Mm-hmm.
Okay, so go down there, get started on probation. You have any questions about anything?
No, sir.
Anything further, Mr. Camper?
Yeah.
For the state of Indiana?
No, Your Honor. Thank you.
Thank you. Best of luck to you, Ms. Britton.
Thank you. Have a good
Sure.
day.
2502 F61577. Defendant appears in court in person without counsel. State of Indiana by Gary Gurman.
Morning, Mr. Jameson.
Good morning.
The probation department filed a petition for revocation of probation on January the 13th of 2026. Have you received a copy of that?
Yes, sir.
All right. Let me go through it real quick. In their petition, they allege that you violated Rule 4 for financial obligations. They said at that time you were behind $60 in your user fees. They also said you violated Rule 9 for narcotics. They attached a drug screen from January 6th that was positive for cannabis or THC.
No, you two don't get to say that. you two don't get to say, hey, he's being mean to me. No, you don't get to say that. You could have said that on day 1. Now it's day 826.
And then they said you violated Rule 15, all of their orders of court for pick-a-dose because you didn't contact or appear for your intake or appointment with the pick-a-dose program. Do you understand the allegations in the petition to revoke your probation?
Yes, sir.
If it's found that you violated your probation, any part or all of your previously suspended sentence could be imposed as jail time. Additional conditions could be added to your probation or an additional length of time added to your probation. Any or all of those may occur if it's found that you have violated. Do you understand that?
Yes, sir.
In a revocation proceeding, you're entitled to a hearing. At that hearing, the state would have to prove by a preponderance of the evidence that you actually violated your probation. Do you understand that?
Yes, sir.
At that hearing, you'd have the chance to confront and cross-examine witnesses, and if necessary, use the court's subpoena powers to have witnesses brought here to testify on your behalf. You understand that?
Yes, sir.
You're also entitled to an attorney. If you can't afford an attorney, one could be appointed for you. Do you plan to hire counsel?
I was going to ask if I get a public defender.
Okay. Please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, sir.
Okay, thank you. And what do you do for a living, sir?
I just got a job and it's shipping and packaging.
Okay. And where do you work in shipping and packaging?
Secure All in LaPorte.
And how much do you earn at Secure All?
$16 an hour.
How many hours do you work each week?
40.
Did you get a paycheck yet?
Yeah. Yes.
Was it for a full week?
No.
How many days did you work on the paycheck?
3 days, Your Honor.
And what was the paycheck? How much?
425, I think, something like that.
425 for 3 days. Was that after taxes?
Yes, sir.
Okay. Do you have any kids?
No, Your Honor.
Where do you live?
I live with my aunt.
Are you paying her any rent?
Yes, Your Honor.
How much do you give?
$200 a month.
Do you have a motor vehicle?
Yes, Your Honor.
What do you have?
Dodge Avenger.
Do you own it outright?
No, Your Honor.
How much money do you pay on it each month?
About $800 a month, but it's only for a couple of months.
You only have a couple more months left in payments?
Yes, Your Honor.
When did you buy that Dodge?
Couple months ago for my little brother.
How much did you pay him? How much did you give him for it?
Originally, I was supposed to give him $2,500 for it, but I was like unemployed for a while, so I haven't been paying him. So now we worked out a payment where I got to give him $200 a week.
Okay. Payday for you, payday for him?
Yeah.
Mr. Jameson, you earn too much money to qualify for the public defender at this time.
Okay.
You need to figure out a way to hire a lawyer or proceed on your own without counsel. So I can't get an attorney going for you with that amount of money and those few expenses, especially because the car loan's going to be paid off, you know, in
Yes,
short
Your
order
Honor.
here. So can't help you with a lawyer today. I will set you over though for a hearing, give you some time to get an attorney going. Have you taken any other drug screens on him lately?
Yes, Judge, we have one that's currently outstanding.
Okay. It hasn't, you don't have the results back yet?
No, sir.
Okay.
Yes,
Okay.
you
Are you going to
Brent.
fail that drug
Yes,
screen?
you are.
No, Your Honor.
Okay. Are you on drug screens at your new job?
Yes, I had to take one to get in.
You did?
Yeah.
You have to stay clean to keep it?
If you get injured, yes.
Okay. Is it a high injury position?
Not exactly. It's more like something could fall on your toe or something like that.
For sure. Got to wear those steel-toed boots.
Yes, sir.
I'll have you back on April the 17th at 10 a.m. Your order to appear back here April 17th at 10. State?
Yes, Your Honor. If he's willing, I would like to ask the court in its order to permit him to return to Picadós for the evaluation and whatever the recommendation.
I'm happy to do that. Mr. Jameson, the state's suggesting that you get back with the Picadós office and get started with that program, which could help alleviate some of the current uncertainty going on related to this revocation. So I'm going to put that in my order that you're allowed to do that. And
Thank you, Your Honor. I was going to ask if I could try that again, too.
I would suggest you stop by there today.
Okay, Your Honor.
All right?
Yes, sir.
All right. We're adjourned. We'll see you back here on April 17th, 10 a.m.
Thank you, Judge.
How
Thank you,
much
Rory.
longer until Oktoberfest? Oh, I need another video. I'm supposed to work. I was watching Judge Fish and okay, we need 30 more minutes, right? So if I do get the docket on the 27th, I'm going to remove all of his pondering because he does ponder a lot. Here, watch this real quick. It's just let's see if anybody knows why I picked this one clip. It's only 2 minutes long. Nothing happens, but I still got it anyway.
Or whomever.
These proceedings are being recorded live streamed. Criminal Court D36 is now in session. The Honorable Stephen Rubik presiding. Calling the first case, Carlton Kelly, 49D 362502 CM006124. Kelly.
Defendant is present remotely and with counsel. We're set for a compliance hearing. Mr. Kelly, good morning.
Good morning.
Mr. Redmond.
Thank you, Judge. Trying to find a way to not do the reverb, but Mr. Kelly was ordered to complete some community service hours. Mr. Kelly, have you completed anything yet?
Yes, I have.
Judge, I haven't heard anything about him completing anything yet. If we could just have another compliance hearing in due course.
State, do you agree to a final extension of time?
Yes, state agrees. I think this was entered into in September of last year. So the state would just note, please provide documentation of that community service work hours to Mr. Redmond, and he can provide it to the state.
Kelly, are you local? Are you in Indiana?
No.
Whereabouts do you live?
I'm in Pennsylvania, Hershey, Pennsylvania.
All right. The chocolate capital of the world.
Yes, sir.
We'll go ahead and set a remote hearing April 10 at 8:30. You'll log in then. You'll need to stay in contact with Mr. Redmond about your community service work. And we will see you in April, sir. Have a good weekend.
Right.
I want to go to a care facility. They just for the activities alone. They have all these activities you can do every day, and Jello.
A little bit more than usual, but it's just so the area and little church house. So we want to keep this safely.
I can proceed, Your Honor. My client, Eric Stoffel, filed a rule to show cause, I believe it was back in December, actually January. This is the second rule to show cause that has been filed in the past 6 or so months. He filed a rule to show cause in June of 2025 that the court essentially did not make any ruling on due to the DRCD being involved in this matter. However, we filed the second verified motion for rule to show cause in January due to continued issues with mother complying with the party's current parenting time order that was pursuant to a 2023 stipulation.
Can you read me the specific language there?
Certainly, Your Honor. Pursuant to the stipulation, father's present parenting time is to be supervised by mother every Wednesday from 4 p.m. to 6 p.m. and every Saturday from 12:30 to 2:30 p.m. The order also provided that the parties were to continue using app close to communicate with each other about the minor child, and that if there were issues relating to parenting time, they needed to use that to send a message to the other party. The stipulation also provided that the parties were not to engage in disparaging language about the other parent to their child. And so those were the provisions at issue.
Can you tell me why was there a need for supervised parenting?
That had been in place since the divorce decree had been entered. There is a motion to modify custody that is pending, and the DRCB is currently doing an investigation on that.
Was there some alcohol use or some other issue?
There were concerns about alcohol abuse at the time, yes.
Your clients get any alcohol issues since?
Yes, Your Honor, certainly with respect to the filings of these rule to show cause. In fact, he has been doing the backtrack breathalyzer test every day and submitting those results to mom. There was no order in place.
Order or voluntary?
Voluntary.
Okay. So what are you seeking? Make up parenting time?
At this point, we would seek to make up parenting time and just in order from the court to have mom comply with the current agreed stipulation that she work with dad in the event of there being issues with scheduling of parenting time. I know Lucy is involved in activities, but oftentimes mom will tell father at the last minute. And
Lucy,
yes, I'm sorry. Yes, Lucy is.
How old is Lucy?
She's 10.
So Wednesday 4 to 6 has been inconsistent or not at all?
Sir, probably over the last 3 years, there's probably been 80 to 100 times that she's given any excuse. I've heard birthday parties, cheerleading, sleepovers, COVID, you name it.
Okay, Wednesday 4 to 6, when's the last time you had parenting?
Yesterday.
Before that?
The previous Saturday, I took Lucy to the mall.
So I'm talking about Wednesdays. Wednesdays.
We've pretty much been doing Thursdays, which was kind of an agreement between Ashley and I, due to Lucy has cheerleading / gymnastics on Wednesdays from like 7 till 9 p.m.
So Thursdays you've been doing?
Pretty much Thursdays.
When's the last time you missed a Thursday that seemed improper?
The last time I missed would have been a Saturday about a month ago.
I'm talking about Thursdays or Wednesdays.
Thursdays or Wednesdays, or it's been a while on that.
So it's worked out okay for a while?
Yeah.
On Wednesday to Thursday?
Correct.
All right, I'm talking about Saturday.
About a month and a half ago, Lucy had cheerleading in, I don't know, Indianapolis, I believe it was. 2-3 weeks later, it was cheerleading in Ohio. And you got to understand, these cheerleadings are Saturday and Sunday typically, so I can't even come over Sunday then.
Maybe you can take your daughter to her cheerleading competition.
Okay, so you've talked about 2 cheerleading interruptions for which you did not get makeup time.
Correct.
If you can detail specific misses because of other activities, then I think we need to talk about makeup.
Well, over the last 3 years, I mean, I'm not joking, there's been 80 to 100 times of.
So that's too vague. Any specifics?
I mean, I have a list on my phone over now. I think we can propose them.
Can I ask some questions, Your Honor?
Okay.
Have you, You just testified to having issues with parenting time due to cheerleading competitions. Is that correct?
Correct.
And you said the last issue with that was approximately 4 to 6 weeks ago?
Correct.
Was any makeup parenting time offered for that?
No.
Did you request an alternate time in lieu of that?
Yes.
What was mother's response to that request?
No response.
And by no response, you mean she did not respond via like text message, or what do you mean by that?
Yeah. No text message, no call, no conversation.
Prior to that, were there other Saturdays that you missed in the recent months? And by recent months, let's limit that to the past 3 months.
I don't believe so.
So you're asked, how many Saturdays in the past 3 months are you asking that the court consider for purposes of makeup parenting?
At least 2.
Okay. At least 2 due to those 2 competitions?
Yeah.
Has mother given you advance notice of those competitions?
Most of the time I find out from Lucy, actually.
Okay. So mother's not the one to communicate that to you?
No.
When you have these conversations about competitions and or makeup parenting time, is it the day of when you're supposed to have parenting time, or is it the day before? When do you ultimately end up communicating with mother about this?
Typically. Most of the time I've asked for previous times of what is she going to make up this time? No response before and after the event, because it's a continued pattern of Ashley's.
Have there been events more locally that caused you to miss parenting time?
Yeah, there was, Lucy had a cheerleading event at the Elkhart RV, whatever, Hall of Fame place. And
when was that?
About 2 months ago.
So November, December?
Yeah, roughly. And me, Sarah, and Max went, which Max is my stepson, and actually made a scene in the place, of course, in front of Lucy, because we sat in this area that is the VIP section. Well, you sit in that section when your kid comes up to perform. Well, I saw Lucy go back around the stage behind the curtains, and I figured she was coming up next. I've never been to a gymnastics / cheerleading thing because Ashley never provided me the schedule. This is the first time I went, and I didn't know. So we.
So, no one goes up to her and hands her a schedule, right? Nobody just says, here's her schedule. No. She has to go through hoops to get the schedule. The exact same hoops that you are free to go through yourself to get that schedule.
Sat there for like 3 performances, and like the 3rd or 4th one, Lucy finally comes out. So after Lucy got done performing, we're sitting in these chairs, mind you, right in front of the stage where all the kids are at. And Ashley's basically berating me and Sarah and Max about why we're sitting in the VIP section when Lucy's not performing. Then her sister gets into it. Sister Melissa then starts adding to the fire. I mean, it was so uncomfortable at that point, we had to leave.
Was that on a Saturday?
Yes.
Okay. And so during what would have been your parenting time?
No, this was in addition to that. So that later that Saturday, I didn't go over there due to that because,
okay,
that morning I was so frustrated.
Did mom prevent you in that situation from having parenting time, or did she communicate with her about, or did she communicate with you about Lucy not being able to participate in parenting time that day?
I think I texted her that I wasn't coming over.
Okay, so that you're not asking for that day at that point, since you indicated that you couldn't go.
Well, I think I deserve it. I mean, it's to the point that I mean, in addition to whether it was over, I mean, she's got her mom and her mother-in-law and Melissa and her, and they're all pointing at us like, get out of here. I mean, it was.
So in addition to that, I would certainly seek a reprimand to mom disparage your father. There is an order I mean, there's a stipulation, but it should go without saying that the parties are not to disparage the other parent in the presence of the child. Not only is that, detrimental to the other parent, but it's most detrimental to the child. Regardless of what's going on between the parties, the child should not, to the extent that she can be protected from that, be privy to all of that. Quite frankly, Father just gave the example of the interference with him attending an event to support his daughter. But even last week with this rule to show cause pending, Mom had contacted the school saying that Father couldn't attend a school play due to the parenting time order that has him having supervised parenting time. And that is not what the court's order says. It says that he has supervised parenting time those days, but it doesn't prevent him from attending something like a school play or a school activity. And so this seems to be characteristic of Mom, that she's trying to interfere with Father's relationship with the daughter. And quite frankly, it seems retaliatory that she contacted the school to advise the school that he shouldn't be attending school play.
Thank you. You may respond.
I'll do my best, Your Honor. Just to let you know, these parties communicate via app close, and there are over 300 pages in the transcript of the app close alone. A lot of that outlines the communications between the parties. I know we're not set for a full evidentiary hearing this morning, but in order to fully ascertain whether or not Mother has voluntarily and willfully disregarded the court's order, I think there's much more evidence that this court needs to hear that it's not going to have time to do today. In addition to that, the reason that Judge Steele did not set the first contempt filing for hearing that was filed, I believe counsel said back in June of 2025, is because that same stipulated order requires that this was the pending or interim order pending the outcome of any report or recommendation made by the DRCP. These parties are still going through the process of doing services through the DRCB. In fact,
when was their first referred to the DRC?
You might more. I go ahead. So the parties had stipulated, I believe, in July of 2023 to referring it to the DRCB. I don't think there was much follow through on that. So then in 2025, when things were going well with the parties, and then they weren't. So in 2025, the parties then sometime in the summer stipulated, I believe it was in July of 25, entered in stipulation regarding re-referral of this matter to the DRC.
8 months or more?
Approximately, yes.
How long does it usually take for the DRC?
I think it's different in any case, Your Honor, but we did just have an updated report filed, I think just last month by the DRCB to indicate that the first thing that they did with these parties was kind of attempt numerous mediation type sessions between them, and they weren't able to reach agreements. And so that report to the court just last month indicates that they're going to move on to the full evaluation process. And so I just want to note for the court, that we kind of kicked this issue down the road, so to speak, the last time because the DRCB is working with the parties. But that being said, to circle back to counsel's argument about the contempt allegations, the reason for supervision was not just alleged alcohol abuse. Mr. Stoffel had 5, if not 6, criminal open cases that all related to the abuse of alcohol and driving under the influence. And so there is a very, very long history. It wasn't simply just something that stuck around because it was in the decree. There is a...
You have your driver's license?
Yes, sir.
And when's the last time you had alcohol-related traffic or...
Oh, these were 2023. And by the way, I have 2 convictions, not 5.
I didn't say convictions.
Okay, so you don't have any pending matters?
No.
You go to AA or any other?
Yes.
You get clients from that, or how do you prove you've been?
There's a signature list. Someone signs off that you went there
How often do you go?
every Monday.
What's it called?
It's in Union, Michigan.
Okay.
I just wanted to give the court that history, that it wasn't just some tossed up in the air allegation. There was
So there's a serious alcohol history.
Correct.
And maybe not current, but he's not driving, your client's driving.
That is how it is supposed to be. I believe that Mr. Stoffel is off of all court supervision and things like that, and so there might be some driving of Lucy, but not to get too hard.
Let me hear more about that.
No, I pick her up every Wednesday or Thursday, every Saturday.
So your clients agree to parenting time that includes transportation of the child by father.
We were working with the DRCB, with the breathalyzer that he would do before picking her up. So that was just because we were working with them, trying to, move forward.
We agree.
Yeah. So you see the blood alcohol content results before letting Lucy get into the vehicle with her father.
If he sends it beforehand. Yeah. It's only been for a couple times.
Okay. Address specifically the Saturdays where mother and child have been to some extracurricular activity.
Sure. I also want to point out one more part of the order that I think is important here. So in addition to the parties communicating via app close, father was supposed to share his work schedule with mother, because when the agreement was made for these days, father had some work obligations at some times, and the parties knew that there would be different days that they would have to agree upon. And that communication takes place within app close. Like I said, over 300 pages of this. Father has never provided that work schedule to mother.
Let's find out why not. Do you have a work schedule?
Currently, I work 7 a.m. to 3 p.m.
You don't need to tell me what it is. Do you have a schedule?
Yes.
When do you get it?
My schedule's the same every week now. That just recently changed.
Say that again.
My schedule's the same every week. That just recently changed.
So did you tell her about it?
She's never asked about it.
Did you have an order to tell you to send it schedule? What's the quote you ordered in Tom sheet?
I mean, the first time she never did it.
I want to know if there's an order to deliver dad's schedule.
I believe it was in the parties mediated settlement agreement, but I'm looking for the specific language for you just a moment. All right, so this is paragraph 6 of the mediated settlement agreement. And it says the parties may agree to change the days and times due to Lucy's activities or father's work schedule. Father shall provide his work schedule to mother through the app close app. This is the operative order that resulted in the times and supervision that was carried over into the July stipulation that they're operating off of now. I don't think that there was ever anything that changed that order or that requirement, and that mediated settlement agreement.
Okay, well, let's make an order today, reinforcing what was before. The dad will confirm his work schedule once a week. Just send an email, app close, and mom's going to provide schedules of any extra curricular activity for Lucy.
That's an app close, and she has been doing that. So that's what that's what I indicated. And if I get into the contempt allegations as well, there are, I believe, no instances, and I can have you put my client under oath and ask her some questions, but I believe there's been no instances where she has canceled or rescheduled or changed father's parenting time.
So every Saturday, Lucy's been available for dad to visit. We're saying that?
she's in competitive cheer. And so if there is, in fact, a cheer competition in Ohio or Indianapolis or something like that, father is aware of those. In fact, there's text correspondence where she sent a group message of Lucy's cheer schedule to Mr. Stoffel and his father.
Can she physically be with dad during parenting time for 2 hours on Saturday when she has these activities?
I think that's been offered. And as
where would Lucy be available for that? Here or in Denver?
It would just depend. We are in Ohio for the competition or Indianapolis. But he did come over on Monday, the last competition we had, the Saturday that he was referring to earlier.
So you gave him a makeup time on Monday? One time?
That was for this situation. I always offer makeup time.
What was the day that I made it?
It was the Monday. I would have to look at my calendar.
Okay. So that accounts for 1 and 2. So it looks like there's another makeup they do.
I don't think so. If I could take some testimony from her, maybe we can move through this pretty quickly. But again, there's a lot of elements.
To an order from his force. In the future, you will make their time specifically if you miss a Wednesday, Thursday, or Saturday.
Always, yes. My client indicates that that's what's been happening, Your Honor. And without us putting all 300 plus pages of app close in front of the court, having witnesses from the school, witnesses from this cheer competition that happened at the RV Hall of Fame, the court is not going to get the whole story here today just in less than 30 minutes. This is something that really requires a full evidentiary hearing. And with all due respect, I believe my client is following the orders and
so there's a dispute about the past. We can set an order to deal with the future. Make it specific on parent and on makeup.
Sure.
And we just defer other issues until the hearing on modification festival.
I think that seems appropriate given, I would just ask the court to reiterate its order that parties do not engage in disparaging.
Ms. Brainstorm, let you draft and form a order for today.
Yep.
Concerning the issue of past violations of parent time orders, for the evidentiary hearing, which includes all other pending issues. But prospectively, ordering the parties to refrain from disparaging comments about the other party, period, especially in earshot of loose. The dad will confirm his work schedule on a monthly basis. Let's put it that way. Agree?
That's fine.
With your apples, mother will provide copies of extracurricular activities of any kind of Lucy when she receives them through apples to file.
I mean, one additional request, Your Honor, and to just note for the record as well, my client denies that she disparaged father in Lucy's presence or earshot. But the request that I would like to make is, could we please have the order indicate that the app close communications need to be limited in frequency and duration to the matters that pertain directly to Lucy. There is quite a bit of what I would call harassing type messages from Mr. Stoffel to mother that take place in those app close communications.
Mr. Stoffel, the beauty of app close is you get a clear way to communicate. The downside of app close is everything you say is going to be seen by a judge. And if you hope to do well on other hearings, having a record of misbehavior in app close is not going to help you. You understand? Just say, yes, I understand.
Yes, I understand.
So I'm not going to go back and judge what I can't see. But it's foolish to put more than needed of any harassing language that you know a judge is going to be. You understand?
Yeah, my only issue with it is I'll send a message. It'll be 3 days later until she responds. You can see she read it.
Okay. Why don't we stop the frustration by having the time period to respond?
There is one on that. It's supposed to be 24 hours. You're like
reinforce that in this one.
And again, the court doesn't have time to go through 300 pages, and I certainly didn't print those for this morning. But my client,
I'm not condemning one more than
sure, the time period is there, and if it's a substantive issue that requires a response as to Lucy, she responds within that time frame. I myself have instructed her if it is a repetitive, harassing type message that has nothing to do with Lucy, for her to not respond, because that's opening the door for that kind of behavior to continue.
Again, I'm not going to judge what I don't see. But if you continue to send messages that don't relate to your daughter, again, that's a negative factor. It's not going to help me in case you're hearing. But conserve your use of that communication to the really appropriate Lucy-related issue. Okay? You got to add that as a motion.
Yes.
Okay, I'm going to end the hearing this time. I'll show that parties appear in person by their terms of record. The hearing and follows will show the call. Hearing had ruling reserved pending round order to be submitted by the dates. Okay? Thank you.
Thank you.
So the judge didn't want to look at any of the messages, but they were ready to show. Not only did she send him the cheer schedule, she sent it to him and his father. He keeps sending harassing text messages. 300 harassing text messages. None of them about the child. He's only allowed supervised visits. That's what he's allowed. Supervised visits. But the girl is in cheer. He can take her to cheer. He can take her to her cheer competitions. Unless he wants her out of cheer. I mean, he has the full schedule. He did tick her off. So you're at a cheer competition when your child is about to, or gymnastics competition. When your child is about to go up and do something, tumble or balance beam or whatever, you're allowed to move up to this one section and watch your child. And then you got to leave so that the other parents and grandparents can go up and watch their child. He just stayed there the whole time. He just stayed there the whole time. And she's trying to tell you're not allowed to sit here. Why are you sitting there? You're not allowed to sit there. The reason why he doesn't know this is because he doesn't go to the cheer competitions. He had all of those visitations that weren't that, or she switched it to Thursday for him. It was ordered for Wednesday. She switched it to Thursday for him. He was supposed to give her his work schedule. He never gave her his work schedule. Never. He gave her 300 harassing text messages in WhatsApp or AppClose or whatever, but none of them was his work schedule. So he misses. He doesn't call. He doesn't do anything. He just goes on with his life when he misses. But then when she says, oh, they have COVID, they're sick. She's sick. She can't come, she's sick. Because it's a supervised visitation. Then he's like, oh, she keeps canceling. When did they do this, sir? 3 years ago. 3 years ago? She did it 3 years ago? Is that what you're talking about here in this hearing? Yes. Okay. So the lawyer's like, we have all of these messages to show you what's going on, Judge. The judge's like, nah. I don't need to see all that. I don't want to see all that. But everything he said at the beginning, she was like, wait a second. I have receipts. I don't know. It's just frustrating. These child custody cases are frustrating. Only because I know, how hard it is to be like, you haven't tried to get your kid in 4 months, and now you're wondering where all your visitations went. And the kid is right here. I want the kid to go to you. Get this thing out of my house for a little bit. You know what? They said Hershey, the chocolate capital of the world. I need to go get some chocolate right now. Oh, sugar. My car's in the garage. I have chocolate downstairs. I don't need to go nowhere. I can stay home. Guys, go get some chocolate. Eat it. And then If you watch any good court cases today or bad ones, just put it into Discord where you're at, and we'll all come. Bye, guys. I hope you guys have a great day. Thanks for coming out. I appreciate it. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh,